Hi, and welcome to the Capital Forum's 7th Annual Antitrust Thought Leaders interview series, sponsored by KL Discovery. My name is Nate Soderstrom. I'm here today with Jesse Solomon, who is a partner at Davis Polk. Jesse, thank you for being here today.
Thank you for having me.
Antitrust covenants. Yes. Hot topic. A lot of antitrust uncertainty in this environment. How, when you're putting a deal together, when you're working with M&A folks, how do you think about structuring purchase agreements to allocate antitrust risk, especially given the uncertainty we have in this day and age?
Yeah, absolutely. I think your question hits on sort of a synthetic aspect of antitrust law, which is this idea that you are, as an antitrust lawyer, making a litigation assessment and then trying to figure out a way to control for that risk of litigation in the transaction agreement. And there are a couple of different provisions in the purchase agreement that would typically go to those issues. So the most common would be the risk allocation clause, in which the parties divide between them what will happen in the event of an antitrust investigation or an adverse antitrust decision. But another, for example, that I think is in some ways the most critical starting point for us is the outside date for the purchase agreement and how long the parties are giving one another to be able to get the regulatory clearances that are necessary. So as we think about the various different points along the spectrum that are increasingly ambiguous or uncertain in the world of antitrust, I would start by thinking about timelines, frankly. And when I say timelines, I mean not just the duration of an FTC or a DOJ review, but also the duration of reviews that may be conducted increasingly by state attorneys general alongside the FTC or the DOJ, as well as the proliferation of 120 plus regimes around the world that now have merger control regimes. So given all of that and that kind of dynamic landscape, I would think a lot about creating a fairly long outside date in a transaction agreement. And then I think I would go from there to thinking about the risk allocation clause and the likelihood of a remedy, the possibility of a remedy, and whether or not you are in a position of being able to identify a line of business that could be potentially subject to divestiture, or less so today than a few years ago, but a behavioral remedy as well.
We were talking about this a bit before we started.
Yeah.
How do you think about the question of roadmap risk, the idea being you have a merger agreement, the buyer agrees or is obligated to divest assets accounting for up to, say, $50 million in revenue. Mm-hmm. There is some business that very well could be an issue that's $49 million in revenue. It's pretty clear that that's what that's going to refer to. When you have something like that in a merger agreement, is there a concern that you're giving the agencies a roadmap to figure out what you think is an antitrust issue and therefore maybe increase the likelihood that they're going to demand a divestiture?
Yes. That is the conservative and traditional view, is to be cautious about roadmap risk. Now, you can say, and I think what your question is hitting on is an idea that maybe there is ultimately not so much difference. And I will say that I know when Bill Baer was the head of the antitrust division, he spoke about this very issue. And the point that he made was that the antitrust division conducts its reviews on the merits of the transaction and not with some sort of idea that it can game its review or game its negotiations with reference to the commitments in the purchase agreement. With that said, the Halliburton-Baker Hughes complaint from about April of 2016 or so was one in which the DOJ explicitly cited the transaction agreement and various provisions as proof right up front in its complaint of the fact that the parties allegedly knew of anti-competitive harms coming out of that deal. So I think that the signals go in different directions. And I think what I would do in advising a client about that issue is to determine how material the roadmap risk is in any given deal. Now, in some cases, you will want to carve out certain kinds of products for divestiture and agree with your counterparty, I'm willing to divest X set of products, but I'm not willing to divest Y set of products. And that may militate in favor of being more explicit.
Right, that makes sense. As far as recent developments, last 18, 24 months.
Yeah.
Has there been anything you've seen as far as what's market on antitrust covenants, any kind of new novel provisions you've seen? how have you seen things evolve over the last couple of years?
Yeah.
And anything notable there?
Yeah, there are a couple of things that I think are interesting. I think one of the ones that I think a lot about is reverse break fees, because as you approach an increasingly ambiguous environment on antitrust, you approach the possibility that you may not be able to get the deal done, or that you may not be able to get it done within a time frame in which the deal would make sense for a board or for shareholders. And so in a circumstance like that, you need to find some way of being able to compensate the target with some kind of a break fee if the buyer can't get the deal done. And those break fees have been paid in AT&T T-Mobile and in Electrolux GE and other transactions. I think that we are seeing more in the realm of break fees. But what's interesting is I think somewhat less of a percentage of deal value in total. So just to give you an example, in AT&T T-Mobile, which was almost 10 years ago, about 2011, I think, the reverse break fee there was about 10% of deal value. If you look at CVS Aetna, Bayer Monsanto, AT&T Time Warner, those are in the realm of 1 to 3%.
Right.
Another thing that I think is changing in terms of what is market is that typically if you go back, say, 5 or 10 years, I think we would have said the buyer controls strategy on antitrust, and you would always have a provision within the risk allocation clause that it's the buyer's deal to defend. I think that there may be reasons to rethink that a little bit, and I'm not sure that that's necessarily market today, but I think we could look at, for example, the Sinclair Tribune dispute and what took place in the wake of that busted merger, and think maybe there are reasons why parties to a difficult transaction would actually want to share control of an antitrust offense.
It makes sense. If you're the target, you're putting a lot of eggs in the basket of the buyer.
That's right.
Being committed, and B, having an effective strategy. And as we recall with Sinclair, sometimes that doesn't work out.
Exactly. But I should just add, though, that these are all different levers, right? And so there are different sensitivities and touch points for different parties. And so as you think about what substantive antitrust risk you are willing to bear and about providing a break fee and providing an outside date on the transaction and who controls, all of these are different levers that you can pull and adjust to sort of meet a particular buyer or seller's needs.
Right, that makes a lot of sense. So to take a step back, and we're talking about an increasingly uncertain or ambiguous antitrust environment, probably the headline the last 18, 24 months was the antitrust division's challenge to AT&T Time Warner. Obviously lost at the district court level, appeals court level as well. On vertical merger enforcement risk, what are you telling clients, and are you telling them something much different than you would have told them 2 years or so ago as far as the risk there?
Yes, I would say so. I think with regard to vertical merger enforcement, I would start again. I realize this isn't sort of the sexiest way to start here, but I would go back to timing and think that vertical mergers are challenging to review, and they're also challenging to defend in a couple of respects. Now, they're not the issues may not be as direct as a head-to-head overlap in a horizontal merger, but they're also challenging in the sense that they, by definition, deal with multiple levels of a marketplace or a supply chain. That brings in more custodians into a second request and more of a need to engage with the agency across a range of different facts. And the effects of vertical mergers are in some ways less predictable in the sense that at least in the sense that we have less of a body of precedent to guide us. There are also multiple different economic models, and this was a point that came out at trial in the AT&T Time Warner transaction about the use of a Nash bargaining model versus a different kind of a foreclosure model. And so as a result, I think that there are ambiguities that suggest a longer process. Now, with that said, I'm not sure that it ultimately means significantly greater exposure. And so if you look at some of the big vertical transactions over the last year, AT&T Time Warner, as you've identified, a deal that I did, CVS Aetna, and Cigna Express Scripts, those, as we sit here today, we don't have a clear precedent of a successful vertical merger enforcement.
Right. No, it's an interesting dynamic. I think another question is around potential competition, which is always a question.
Absolutely.
And we were chatting on this before we kicked off, but DOJ, especially in the egg sector, so you had DOJ's enforcement action in Bayer Monsanto, DOJ's enforcement action in Dow DuPont. And I know when we were talking, I don't want to call their treatment of those issues inconsistent, but there may have been some inconsistency in their treatment of those issues. When you're looking at those two enforcement actions and the treatment of potential competition, what did you see there?
Well, I think maybe something that we might agree on is that this is a rapidly evolving area. And to give the Antitrust Division, I think, as much credit as possible, they conducted investigations into both Dow DuPont and into Bayer Monsanto, entered into consents in both, and that their thinking evolved from Dow DuPont to Bayer Monsanto. And just to give a little context, in Dow DuPont, the DOJ did reference concerns about innovation and potential competition concerns. But when you go from the complaint to the consent decree in that transaction, you don't see a remedy that matches up to that concern, which really contrasts with what the European Commission did in Dow DuPont, where the Europeans required the divestiture of DuPont's entire R&D arm. And then that situation really flips when we get about a year later to Bayer Monsanto, where in order to close the Bayer Monsanto transaction, the parties were required to make significant divestitures in the realm of innovation and potential competition, particularly around digital agriculture platforms.
Yeah. Innovation strikes me as an issue if we think it's a harm from a transaction. It seems like it's difficult to remedy. And obviously the division had remedies in both those transactions. But,
it is.
Again, the idea of restoring potential competition, which I think by definition is an existing competition. Again, if we're trying to restore status quo, how do we restore status quo that we think doesn't exist and won't exist for a few years? Maybe the answer is R&D assets in the case of ag scientists and various other pipeline products. But it seems like a difficult thing in the abstract to remedy.
I think it can be, certainly. And that may be, in part, what is underlying a change in policy at the Federal Trade Commission. About a year ago, Bruce Hoffman gave a speech in which he explicitly advocated for divesting marketed products over pipeline products in the pharmaceutical sector. He limited his statement to complex products, although I think that's a fairly ambiguous body as to what exactly that means. So that could be the case. Now, with that said, I'm not sure. I think that there are things that parties can do to ensure continued innovation. And so I would want to be thinking about, in defending a transaction, I would want to think about a demonstrated track record of continued investment in products, demonstrated plans to continue developing products, and assess and to be ready on the economic incentives for continuing to do so.
Right, that makes a lot of sense. So I think between covenants, vertical mergers, and potential competition, we've addressed the entire universe of merger enforcement.
Yes.
So excellent. So with that, we'll cut it off. Again, Nate Silverstrom with the Capital Forum, Jesse Solomon, Davis Polk. Thank you for being here today, Jesse.
Thank you very much for having me. Appreciate it.